Morning, ladies and gentlemen, once again. Can you hear me all right? I hope so. My name is Martin Kuravi and I will moderate this grand panel discussion. It is my great pleasure to welcome our distinguished guests here, and I will just briefly introduce them. Richard Moberly is a professor of law at the University of Nebraska in the United States, and he is not only an academic but also a very active fighter for the implementation of legislation in order to protect the potential whistleblowers in the United States. My second speaker and distinguished guest is Tom Devine, who is a legal director of a non-profit organization called Government Accountability Project, and he has been very active in promoting and defending whistleblowers for the last 35 years almost. Then it is my great pleasure to welcome Mr. Libor Michalek, who happens to be a member of Senate, which is the upper chamber of the parliament, and also he is a former whistleblower. Last but not least, it is my pleasure to welcome Mr. David Lewis, who is a professor at the University of Middlesex in the United Kingdom, and he is an expert when it comes to employment law. And I would just start with a very brief quotation said by Oscar Wilde more than 100 years ago. He said, "Man is least himself when he talks with his own person, but if you give him a mask, he will tell you the truth." And I think it's kind of related to what we are going to discuss today. Here in the Czech Republic, we do not still possess any coherent legislation which would be good enough to protect potential and actual whistleblowers. We have several rather imperfect instruments scattered all across different laws and legislation, but still lacking one single overlapping law which would do that job. And as we speak, the government is preparing that sort of legislation as an integral part of its attempt to fight corruption. And the current government declared that protection of whistleblowers should be one of its key principles and elements. And my first question, therefore, would be to all of our speakers. I would like to know if such a thing as one single law that can efficiently protect the whistleblowers is actually needed, or if there is enough space to ensure the protection of whistleblowers otherwise. I will probably start with Richard, if I may.
It's a great question. I think, so I have two parts of the answer that at least I'd like to address, and then I'll leave time for others, of course. I mentioned this a little yesterday. I think it's important to have a specific law focused on whistleblowing because one, whistleblowing presents a number of issues that other employment law or other types of criminal protections may not address. But also because I think law can serve a very expressive function in society. Law can tell us what the norms are, can help guide the norms and lead the way on building new norms. And if you want to build a society that has a norm where people feel free to speak up when they're confronted with misconduct and where organizations are able to listen to them and address the misconduct, then I think it's important to have a law that talks about that specific process. And so focused whistleblowing law is important from that aspect. And then I'll also say in the United States, our experience is that we don't have, at least in the private sector, we don't have a single overarching law that addresses whistleblowing broadly. We have a number of discrete laws in discrete areas, from environmental protection to corporate fraud. And in each one of those, you have to report on a particular type of conduct in order to be protected, rather than a broad law that protects all reports related to criminal misconduct or waste or abuse of authority. And what we find is that oftentimes whistleblowers get second-guessed after the fact on whether they reported the right type of thing to be protected. And I think that's just a trap when you have those types of discrete areas for laws. A broader definition of what can be reported will be much more protective and much more encouraging for whistleblowers. So there are two thoughts to get us started.
Yeah. Would you like to comment on it, Tom?
Sure. The first point that I would share in response to your question is, yes, we do need laws, and we need one comprehensive national law. Laws in themselves, as will be most of my answer, are necessary, but certainly not sufficient. They're not the solution by passing a law. But laws are the path breakers, the pioneers to be changing social norms, and particularly in countries where there's a cultural, there's going to have to be almost a cultural revolution to accept freedom of speech in these particular contexts. You need the law to define legitimacy and to pave the way for social acceptance. So I don't think that we can really make significant changes in deeply ingrained traditions without having some sort of a change in the law as the pioneer for that shift. The second thing that I'd say in response to your question is to learn from the mistakes of the United States, where we have 58 whistleblower laws, 48 for the private sector, 10 for the government sector, and that's just at the federal level. And no one really knows what their rights are. There needs to be one law that establishes clear boundaries so that both those who want to engage in dissent and those who feel threatened by it know what the rules of the game are, what the boundaries are, and nobody's flying blind. The third point that I'd like to make, though, in response is the main one, which is that laws are not enough. I've worked with over 6,000 whistleblowers, and I tell them that no matter how strong the evidence is, and no matter how strong their case is, if the only thing they've got going for them is the law, they're in big trouble. And they might want to reconsider their plans. And the reason for that is one of the primary lessons that I've learned is that the magic word to what we nickname whistleblowing in the U.S., commit the truth and get away with it and make a difference in the process. Magic word is solidarity. When that happens, the whistleblower almost always succeeds. The black magic word that is fatal is isolation. If all you've got is the evidence and theoretical rights, it may be dangerous to know too much. And where I work, we don't really do legal cases. We do legal campaigns. They're like political campaigns, only they're campaigns for the truth. And I made a few pictures that help to illustrate it because it's so simple. When you start out and the whistleblower comes in the beginning, when they know something, this dot represents the employee or the citizen, the whistleblower. This circle is the organization, the corrupt organization where that person is placed. When that happens, all the pressure is to keep the truth inside the circle. And what we do at the Government Accountability Project, very simple. We expand the circle. We play matchmaker between the isolated whistleblower and all the people in society, all the institutions in society that should be benefiting from their knowledge and from their information. We pass the information. We pass it to law enforcement. We pass it to the competitors of the organization that's engaging in abusing its power, to the media, to the victims, the people who are directly hurt by it, to the NGOs who have committed their lives to dealing with these issues, to the parliament or the legislature. And when that happens, the balance of power shifts. Instead of the corrupt organization surrounding the isolated whistleblower, it's society surrounding the corrupt organization. And when that happens, even major multinational corporations or powerful government agencies, they can't overcome those sorts of odds. And when that happens, there's nothing more powerful than the truth. Is the answer to your question?
Oh, yes.
Absolutely, the law is necessary, but it's not sufficient.
Thank you. Mr. Michalek.
Thank you very much for giving me the floor. Good morning, everybody. I also believe that it is necessary to have one single piece of legislation, and some years ago, together with other senators, we proposed a draft law, and maybe later we will discuss it further, but unfortunately it wasn't passed by something like 4 votes. And I believe now that if the legislators want to issue a clear message and give the public a clear message that a problem is important to be solved, it is really necessary to prepare one piece of legislation which is clear and comprehensive, so that everybody can use it and know what their rights are. That is really important signal to make. On the other hand, I completely agree that legislation is necessary, but it's not everything. Let me give you an example. And now when preparing legislation, we approach about 100 state institutions, both state companies and other administrative bodies. And already back in 2013, we asked them if they apply Article 134A of the Labor Code, which enables for an employee to get rewards if an employee meets goals. And these goals were to save money of the agency. And back in 2012, the potential savings could amount to 65 billion Czech crowns, which is an enormous number. So that is where the state loses money on external experts, on legal experts, IT experts, PR experts. So that's how the state mismanages its funds. And sometimes, who knows where this money ends, illegal financing of political parties, or who knows. So we asked all the agencies if they used this Article 134A in doing this and try to save money to the institution, and if they reward them for it. And none of these agencies said that they actively encourage people to save money because they can get reward. And what does it show us? It shows us that back then in 2002, it didn't seem to be in the public interest to save money, because all the NGOs tried to spend all the money they were allocated in the budget. So sometimes they spent money on completely useless services or overpriced services. The money wasn't spent efficiently, only to be able to spend all the money they were allocated, so that next year they will get the same amount of money. So that is just to illustrate that if the government, if the state does not very actively promote that they do care, that they do want to save money, if they do not signal very clearly that they want to reward those who help them to save money, who identify where savings can be made, where the system is not efficient enough, then we can hardly expect the same agencies and offices to do it with a new piece of legislation. We can't expect a new piece of legislation to be really applied and used.
David, please.
Thank you. I'm sorry, Chair, but I'm not going to dissent from anything. There's going to be not much debate here. There's really not much I can add. Tom has mentioned the US experience of bringing things together, the need to bring things together. I gave an example yesterday. It's worth repeating because it's a recent example in Ireland where the problem was that there were pieces all over the place, different sectoral legislation, many sources. People were unaware. Putting things together in one place is important. People have to find they have to be able to find their rights. On the question of the law being comprehensive, it's worth emphasising that the law must deal with whistleblowing, but also related issues about possible defamation claims. Is there immunity from defamation claims? Is there immunity from criminal action? Is there an overlap with data protection? It must cover national security, so we want, I recommend a single source that deals with the outlying issues, if at all possible. That's something to learn from the UK and elsewhere, where there are outstanding issues. There is no mention of the interrelationship with data protection legislation. There is no statement about immunity from defamation law. There's an assumption that if you disclose in the public interest, and the court recognises that, you will get the benefit of qualified privilege in defamation. But that is not stated, so people get fearful. The employer says, unless you can prove what you're saying, I will sue you. That's not what whistleblowing is about. It's about raising a concern for other people to investigate, to prove and disprove. So you need, I think you need one law. It's got to be a comprehensive law that deals with outlying issues. Finally, the need to implement the law, obviously, but to communicate it. It's quite shocking. I think you will be shocked when I tell you in the UK the legislation has been in force since 1999, but the latest polls, surveys of the public, show that still a minority of people have heard of this legislation. So you have to have the legislation, you have to communicate it, you either require employers to communicate it, but what about a public information campaign? Governments do this on health and safety matters. I'm just suggesting it's no good having the law if people don't know about it.
Thank you. I think we can agree upon the fact that it is important to have one comprehensive law dealing with this issue. But my second question would be, how specific should the law actually be? Or are there any specific conditions without which the law would be toothless? Maybe I'll once again ask Richard to begin.
I missed the second part of the question.
If you could possibly identify some aspects of the law which shouldn't be omitted.
Well, I'll pick up on a theme that I spoke about yesterday. I think the more specific you are on the people who should receive these complaints in order to in order for the whistleblower to be protected from retaliation, I think becomes more dangerous. I think you should identify a broad range of people who should receive these complaints. Yeah, you know, in general, the work that I've done in the United States, what happens when whistleblowers really get trapped by these laws, I think, are where you have what we would call in the United States Monday morning quarterbacking, which is kind of after a game, looking back and saying, oh, they should have done this, they should have done that, or hindsight's 20/20. And I think that the more provisions you have in a law that gives specific requirements in order to receive protections, the more dangerous it can be for a whistleblower because they get second-guessed. And I absolutely agree with David that people just don't know about these laws. And it's my conviction that people report things because they think it's wrong and they think other people want to know about it. And then they find out later that it was actually really dangerous. And so if you put a bunch of requirements on their reporting up front, I think people won't know about it, they won't follow them, they'll report, and then they won't be protected. So the broader it can be in many of the areas on who they report to, what they report about, I think that becomes really important.
Thank you. Hey, please, Tom.
Thank you for that question. I was talking about a number of those factors yesterday, but there are so many that it's easy to lose the forest from the trees. The four cornerstones, in my experience, for a whistleblower law that will be effective is first to have the free speech rights available when and where they're going to make a difference and where they're needed, because they're tough spots to be sticking your neck out. That means no loopholes that are arbitrary. It means these are rights that you can count on when we need to exercise them without any artificial limitations or restraints. The second is fair rules of the game to win your case if you have to act on those rights. If the rules of the game are rigged, the whistleblower law becomes a fraud that will increase cynicism and greatly increase retaliation victims and associated secrecy. It will create a net chilling effect without fair rules for what it takes to win. The third is independent due process to enforce those rights. That means a fair day in court that's not controlled by the institutions or parties who are threatened by your exercise of freedom of speech. Far, far too many of the laws have this fatal Achilles heel in them. In the fourth cornerstone is remedies that eliminate all of the direct and indirect effects of retaliation. Otherwise, you're liable to still lose by winning. The premise for all of these cornerstones is transparency. I've been just amazed at some countries that have whistleblower laws to protect freedom of speech, and then you can't research the decisions, who won and who lost and why for those laws. You have a secret transparency reform. Well, it doesn't get much more hypocritical than that. So a free speech law has to be transparent in terms of how it's interpreted and how it's working.
Thank you. David, aren't you afraid that too broad a law will make it inefficient in practice?
Yeah, I have a slightly different view here. I think my view, I take Richard Moberly's point about having a law that's too specific in the way it requires whistleblowers to do something in a certain way at a certain time or whatever. We have to give those who are blowing the whistle some latitude. They may be unfamiliar with the process. However, that doesn't mean we should give latitude to employers. I think the legislation can impose obligations on employers. For example, if there's a concern, it should be taken seriously. It should be investigated. If there's wrongdoing, that should be dealt with. There should be feedback to the whistleblower. The number of reports received should be transparent. So I think you can have legislation that gives some latitude to the whistleblower, but actually put specific obligations onto employers. As was said many times yesterday, the important thing for whistleblowers is that the wrongdoing gets dealt with. They don't want compensation damages, they don't want rewards or thanks. So I think the legislation can be both broad and specific. Finally, and this is based on my experience in the UK, but I think it's similar experience elsewhere, the legislation should not give too much discretion to the adjudicators, to the judges. We've looked at the question of motivation in good faith. We don't want, I'm sorry to repeat this, I don't want judges trying to identify what a person's motive was many years ago when they blew the whistle, as opposed to how they appear today. I think that's irrelevant, it's a waste of time. Similarly, and this may be more contentious, I think it's very difficult to hand over determination of the public interest to the judiciary. What people perceive as being in the public interest is very subjective. I think it's very difficult for a judge to say after the event, I don't think that was in the public interest. It may not, but at what point in time must raising a concern be in the public interest? The public interest is in the eyes of the beholder, and I think latitude has to be given to whistleblowers. The position in the UK, I will repeat, is that the good faith test has been removed from the legislation. We now allow judges to say that what you, as a whistleblower, thought reasonably to be in the public interest wasn't in the public interest. That's a very difficult situation to be in. There's going to be disagreement about the public interest. I'm aware that the judiciary have been given that responsibility, but it is potentially dangerous. It's not necessary to have a public interest test. If people are raising concerns honestly and what they say is true, by definition there is wrongdoing. I believe it's in society's interest that wrongdoing is corrected, whether it's in the public or private sector, and that there is society has an interest if there is wrongdoing in the private sector. If a company is behaving badly, we all need to know this. It's very difficult to have legislation that applies in the public and private sector and to apply a public interest test. What is do private employers have a duty to act in the public interest? In the UK, the duty of a private sector employer is to advance the interests of shareholders. That may not be in the public interest. So a word of caution here about judicial discretion. There's always going to be judicial discretion, but if that is too extensive, it can be problematic, as in other areas of the law.
Mm-hmm. It's interesting to hear that in the United Kingdom, which serves in so many ways as a good example how to deal with situations like this, they actually removed the article of good faith, which, I'm sorry to say, to me seems like a castration of the whole law, because what was basically the logic behind those extradition of that aspect?
Well, the case against good faith was that it was being used to divert attention from wrongdoing. It was the lawyer's technique. If you represent a company and there is wrongdoing or they haven't handled the concern correctly, you divert attention to the motives of the whistleblower, and that was not seen to be within the remit of a public interest disclosure legislation. But I must say, Martin, what I didn't make clear yesterday is that good faith is now not a qualifying condition for a protected disclosure. Mm-hmm. The deal that was done, and this was not discussed in Parliament, the deal that was done is that good faith is taken out as a condition for protection, but may be taken into account in assessing compensation. So in a sense, it's not been removed, it's not so frontally presented, but a judge is entitled to say, I suspect your motives, and on that basis you lose 25% of the compensation we would have given you. Don't get me wrong, that's much better so far as I'm concerned, to lose 25% of the compensation than the judge to say, I don't think you had the right motive, you're not protected at all. But as Tom said yesterday, the thrust is now to remove the test of good faith, because we've got experience, number one from the UK, but other countries can see that you have whistleblowing laws. Who are they for? The whistleblowing laws are for the protection of society, they're to protect whistleblowers. The whistleblowing laws are not for lawyers to make more money, and lawyers will say we have a duty to represent our client, and the accused organisation has got the right to be represented, and we must use everything that the law offers us. Now we're left with an argument about what a person could reasonably believe was in the public interest. It was extremely difficult. But we've moved on from the good faith test. It's just relegated in that way. If somebody said to me, well, you can't get rid of good faith totally, I'd say, fine, put it in compensation, whatever, but do not remove protection on the basis that you're not sure that this person had the right motive.
I see. Mr. Michalek, your proposal of the legislation was not realized, but could you perhaps elaborate a bit on it now?
Maybe I will take it a bit broadly. I will get back to the question of the most important aspects of the legislation. In my opinion, the most important is that it is comprehensive. You cannot really say which individual aspects are important. You cannot really give preference to one aspect. You have to have a comprehensive, because the chain is only as strong as its weakest link, so you need to have a robust, comprehensive legislation. So it is important to have provisions about protection of the whistleblower, and also the whole personal scope, so not only the whistleblower, him or herself, but also other persons, for example, witnesses for the whistleblower who presented evidence against the company, or in my particular case it was the Ministry of the Environment. So not only I was suspended and my salary was reduced, but anyone who wanted to present evidence in support of my claims was being retaliated against. So it's very important to clearly say in the legislation what the personal scope is and make it as broad as possible. Another important aspect is the material scope, what the subject of the whistleblowing should be, when it is considered whistleblowing. Sometimes you hear here in the Czech Republic that it only applies to crimes, but in our draft legislation we also applied it to offenses. And in relation to the EU funds, money management, there were no actual regulations, and sometimes not complying with the rules we had back then could cause loss of huge amounts of money. So we also wanted to apply our legislation on this as well. And the third important field, in my opinion, is the process. Where the legislation says what the whistleblower should do with the information they have. And I agree that the number or the scope of different recipients is as broad as possible. And last but not least is the nature of the protection of whistleblowers, what it means that a whistleblower is protected and how they are protected. Goodwill was mentioned, or good faith was mentioned, and this we could discuss for a long time whether to look into the motivation or not. For example, in my personal case, there was a recording of an interview with close aide of the Minister of the Environment, and he in a great detail describes a transaction that was illegal, a financial transaction. And when I reported on what I heard, then this aide to the minister, he said that it was only a fabrication, that what he was talking about with me in this particular interview was false information, and therefore that I have reported false information and I can be sued for slander at least. So here it is really important that the whistleblower really reports what he or she has heard. We cannot really expect the whistleblower who can judge if the information is truthful or relevant. So that, in my opinion, should the criteria be. Because if I back then went to the minister himself and asked him, I would definitely lose my job immediately. So that's to address the good faith. And another thing that I feel is really important, who the arbitrator should be, who should say if the whistleblower complied with the proper process of whistleblowing that is stipulated by the legislation. In our legislation, it was supposed to be the ombudsperson, and that was probably the key thing which led to the failure of the legislation, because the ombudsperson's office, they don't have enough experts, or at least that's the argument. Of course, you can turn to the courts, but again, in the Czech Republic, court proceedings can take many years, and there is a sort of ping-pong between courts of different levels. So you get the first instance, then to the second, and back. So it's probably not the best way to do it.
So let me be clear, we all agreed that the comprehensive law should be in place, and also most of the European countries declared their willingness to adopt such legislation in their respective national levels. And oddly enough, we still do not have such a norm here in the Czech Republic. So Tom, what do you think is the main reason, and is it possible to compare the situation here with the situation in the United States in respect to the culture? Because the modern history of the Czech Republic is marked with several decades of undemocratic regimes which have had its legacy over us, and we still live even now in its shadow, and whistleblowers in general are not considered as true heroes, which they really are, but still by many considered to be snitches or even rats. So is it possible to focus on the cultural aspect as well?
I think it's a very realistic challenge. And I'm basing that on my experience. Although you held up the United States as a different cultural norm and being a more democratic country, despite appearances, don't overestimate how democratic things are in the United States. We're very, very familiar with abuses of power and repression that's sustained through secrecy. It's a deeply ingrained tradition in our country. And I think that's probably the case almost as an instinct with most governments. It's very difficult to resist the temptation to abuse authority. I think it's almost unnatural to do that. That's why we have to have checks and balances. And statistically, the wind is at our back. In 1978, the United States was the first nation in the world to pass a whistleblower law. Now we have 30 whistleblower laws. And as Mark Worth pointed out yesterday, we've got 30 more that have been proposed and are being considered in other nations. This is a major phenomenon. And I think of it as a legal revolution we're in the midst of worldwide. But laws on paper without cultural acceptance, without social acceptance by any society, really aren't worth the paper they're written on. And that's why I'm most excited, more excited than all the laws that have been passed. I'm excited by the cultural revolution that I've seen. It's not limited to the United States, but that's where I'm most familiar with it, so that's what I'll share. When I first came to the Government Accountability Project and started working there in 1979, whistleblowers were generally viewed as people who were kind of nutty, maybe very, very nutty, or that they were traitors. They were betraying their colleagues and their comrades. Occasionally, they were viewed as profiles in courage, people who stood up to abuses of power and fought corruption. But that was the rare exception. They were generally viewed as nuts or traitors. That was the stereotype. And it's changed dramatically in our country. I first realized that things were changing a lot in 2002, January 2002, when 3 women whistleblowers were Time Magazine's Persons of the Year. You may like or dislike the Persons of the Year, but they're the people who are changing the course of history. They're relevant. They're the major actors who are keeping society dynamic. And when I first came to GAP, whistleblowers were eccentric people who were outsiders, generally brushed aside, and women didn't have good enough jobs to be significant whistleblowers. And I thought, boy, have things changed. And then I knew that things had changed further in 2006. Our country changed the political control of Congress from the Republicans to the Democrats. And there was a survey of the voters who are responsible for that shift in power of what were their expectations for the new Congress. What were their priorities? What did they expect the new Congress to do? The number 1 priority, which was no surprise, was stop illegal government spending. That was chosen by 83%. The number 2 priority, to my great surprise, was stronger rights for whistleblowers, 79%. That was ahead of stopping the war in Iraq, ahead of national health insurance, ahead of lowering taxes, supporting whistleblowers. And in the years since then, we've passed, in our country, we passed the whistleblower laws generally in connection with individual pieces of legislation. But that's when our legal revolution has occurred. We've passed about 15 whistleblower laws since 2006, and they're always passed unanimously. That's because now in our country, no politician dares to be opposed to whistleblower protection. It's like being opposed to the citizens of your country. So yes, it's a major challenge, but it's certainly a challenge we can achieve.
Yeah. Richard, we briefly spoke about the cultural aspect.
Yeah, and actually, I just wanted to talk with Tom about that because I have a question for him. Can I do that? Okay. So when I've looked at in the U.S. This change in culture, that I totally agree that Tom has identified. I look at the institutions and their viewpoints of what's changed, and Congress, for the most part, I think, by enacting in a broad array of whistleblower laws, has demonstrated some of this cultural change. Our Supreme Court, despite being relatively anti-employee over the last 15 years and relatively conservative on those issues, has been broadly supportive of whistleblower rights. Almost every anti-retaliation case that has come before them has been decided for the employee. And so you have these broad institutions that have adopted this cultural change. And then what happens is these whistleblower laws have to get implemented and utilized at a smaller organizational level. An agency has to go and investigate. An administrative law judge has to make an initial decision. A lower court judge has to make an initial decision. And whistleblowers lose those cases. So we have these broad laws. We have the message from our highest court saying protect employees, and yet where the rubber hits the road, I guess is one way to say it, where whistleblowers go to get these protections, they have difficulties. And I'm curious as to your thought, whether you agree with that assessment, and what your thoughts are on the cause of that, why that cultural change does not get implemented on the ground level, where whistleblowers are really trying to protect their rights.
To me, the answer to that is captured in one word that I was describing yesterday. It's consequences. Whistleblowers make a difference in people's lives, and folks appreciate that. You're a little bit grateful when you find out that your children are saved from some illness that shouldn't have happened if it weren't for corruption. Why has culture changed so much? Because they've made so much of a difference. Let me give you a few examples. In 1986, before we passed a relevant whistleblower law, our government collected about $6 to $9 million a year from fraud in government contracts. Since we passed the whistleblower law in that sector, the average is now over $1 billion a year for the last 30 years, and it was $3 billion in one case a few years ago. The LIBOR scandal that was talked about yesterday. Thanks to a whistleblower at one of our Inspector General offices, the United States recovered some $3 billion in LIBOR funds that we didn't even realize had been defrauded from us. Or there's the example of Star Wars. Thanks to a courageous scientist at the Army, the next generation of Star Wars was defeated. There's food inspection. 4 times whistleblowers, hundreds of whistleblowers, have prevented the federal government from eliminating government inspection of government-approved food for food safety. There's drug safety. A courageous scientist at the Food and Drug Administration exposed that Vioxx, the super painkiller, was a killer painkiller that had caused 50,000 unnecessary heart attacks, fatal heart attacks. Almost as many Americans as died in the Vietnam War, only from a drug that our government had officially decreed as safe. Within a month of his Senate testimony, it was removed from the market in our country. They've stopped nuclear power plants from being completed. There were accidents waiting to happen. When the Hanford nuclear waste plant facility in the Pacific Northwest reported that they had lost 10,000 gallons of radioactive waste, thanks to whistleblowers, we learned that the real figure was 4 billion gallons of radioactive waste that was lost, and a major cleanup was started. A whistleblower who won a case in the Supreme Court in January, Robert McLean, prevented the United States from going AWOL during a more ambitious rerun of the 9/11 attacks in 2003, and may have saved many European capitals who were targeted by al-Qaeda in that attack from being destroyed or attacked. I could keep going on for a long time. Why is cultural change happening? Because when we give whistleblowers a chance, they make a difference, and our lives are better for it.
Thank you. David, is the situation similar in the United Kingdom?
Yes, I think we're all in agreement that the cultural context is important and that there can be changes as a result of particular events in culture. I have, Martin, recounted to you already about this situation in the 1990s in the UK. Legislation was introduced in 1998. It was not a government bill, it was a private member's bill. Public Concern at Work, which is the major whistleblowing charity, was set up in 1993, and it had an objective of trying to engineer a cultural change in society so that whistleblowing legislation could be introduced and made effective. There was recognition that whistleblowing had been used pejoratively, it had been used negatively, and that the concept of whistleblowing had to be sold as a positive. However, their timescale was fairly lengthy. An opportunity arose to put legislation on the statute book, and that opportunity was seized because no government had shown interest, so a private bill was therefore supported. So there was an argument that in 1998 the culture was not right for legislation, so the task was to use the legislation as an educative tool and to demonstrate that whistleblowing was a positive. I think that's been a big task. I think it's fair to say that whistleblowing, using your expression, rats, sneaks and whatever, that was still the case. But that was based on ignorance. It was based on the schoolyard thing about telling tales. And things have changed in schools, thankfully. The idea that you don't snitch has moved to, well, you report bullying. bullying is horrendous. Many people suffer from it, and they suffer from it at school, and they suffer from it at the workplace. So I think while in an ideal world you prepare the ground, you wait till society is ready for the legislation, then the legislation fits in. We're not in an ideal world. The situation in the Czech Republic is, well, culturally there will be problems, but they can be overcome, they will be overcome. The Czech Republic is in a position that externally the Council of Europe and other organisations are saying, these are good practice principles, we expect you to comply with them. It has to be said, I think the UK doesn't comply with all of them, but there are external pressures. The external environment has changed. Similarly, in the UK, it's worth mentioning, our legislation says nothing about national security other than to say that if you're employed by the intelligence or security services, you will have no protection. Even if all your reporting is fraud, nothing to do with international relations. If you're talking about theft within the intelligence agency, there is no protection at all. But since the Snowden case, people have been asking the questions about the balance between national security interests and other interests. We have to have a discussion. Now we know what's going on. We have to have a discussion about what freedoms we give up. And I think it's fair to say there has been a cultural change. That, as in Ireland and other countries, there's pressure in the UK to say, well, we're not prepared just to leave the security and intelligence agencies wholly unregulated in this respect. Nobody's saying you treat them the same. You have to have special arrangements. That's what other countries do, more private arrangements. You don't have the ordinary tribunal. So I would say in the Czech Republic, yes, the time is never going to be perfect. It seems to me that, yes, you have to have legislation now, and you use the legislation as a tool in part of this cultural shift.
Yeah. Thank you. There is a question for Mr. Michalek. I will read it in Czech.
How should the coordination of the preparation of the law should be carried out in the Czech Republic? As I mentioned 2 years ago, we prepared a draft law in the Senate, and over the last 2 years we've seen that the Senate and senators, if they know that a government proposal is being prepared, they prefer to discuss about this government proposal. Because as we've heard, the proposal should be prepared sometime next year. So at this point, I don't expect the Senate to try to draft its own law. I myself will definitely try to be part of all the discussions during the preparation of the government proposal.
Richard and Tom, what is the reason why are the whistleblowing laws so scattered and particular? And is there a will to make just one comprehensive law? Please, Richard.
Okay. So, as I understand, the question is, why is it so scattered in the United States? It's my understanding, and Tom can jump in if he thinks differently, is that it was easier when we had the first whistleblower laws were to address very specific problems that were found in environmental regulations, perhaps, and then we passed some laws in the late 1970s. Those were early 1970s. Then late 1970s did more government reform, the federal government reform, and then at that point, as new laws address new sectors of our economy. Those laws came to include, because of the work of Government Accountability Project and other advocates, specific whistleblower protections in those specific laws and areas. I remember you telling me, Tom, when I first asked this question, when I was first coming into this field, why are they so scattered? Why don't we just have one? And you said, well, to get one comprehensive law, it would have to go through 10 different congressional committees who each touch on each of those areas, and it just becomes unwieldy. And maybe you'd like to expand on that, but that, we kind of built it up in this ad hoc way, and so now we have this kind of complicated piecemeal approach and to try and bring it all together may be too much for Congress to do.
Yes, I think Richard kind of nailed the explanation for our country. It's the committee structure of our legislature and Congress allows each committee to have final authority over the subject matter within its specialty. And a whistleblower law, since a comprehensive whistleblower law would have to affect all activities in society, every committee in Congress would have to pass it. It's really a reflection of our dysfunctional legislative structure in the United States. I do want to qualify that, though. We have one core whistleblower law for the federal government employees, the Whistleblower Protection Act. And that's kind of the model that most of the state government whistleblower laws have followed. They have their own twists, but they're very similar to that. And on the corporate level, although we have 48 laws, almost all of the modern laws are kind of like duplicates of a law which was fairly comprehensive in the Sarbanes-Oxley financial reform of 2002, which set up a new system of whistleblower rights, which was in addition to all of the scattered previous ones that are consistent, uniform for all employees at publicly traded corporations, those which issue stock. So it's not quite as dysfunctional as it seems. But I don't think this is a real severe challenge for most countries. I've studied all the whistleblower laws around the world, and the United States is the only nation that's that dysfunctional. Most nations, almost all nations, have one set of rules, and it covers the whole society, government workers, corporate workers, volunteers, and increasingly, just any citizen who wants to exercise freedom of speech to challenge abuses of power betraying the public.
Thank you. You just touched another question which is targeted to all of you. Are there any countries which could serve as a role model for us and could be an inspiration for the Czech Republic? Please, David, if you can start.
Yeah, I think that's... It's very difficult. I think Tom's looked more or less at everything going here. I think one thing I would say is, yes, you want to look at best practice from different countries, not to take one, take the best because that's the intelligent way of doing it. I'm one of these people that take the view that there are bits of legislation, and Tom may correct me, that look too good to be true. That it's a wish list, it's how everything should be, but you've got this awful suspicion that in practice the law can't be invoked. I may be wrong, Tom, I looked at legislation in Jamaica and it seemed to be really cover everything, but I had my suspicions as to whether anybody in Jamaica knew about it, never mind actually relied upon it. So it's very important to look at the principles, and the principles are set out in the Council of Europe, to look at how various countries deal with it and to take into account your own situation. I'll give you an example of a problem of borrowing a model in the whistleblowing field. When South Africa moved on from apartheid, they were desperate to have a set of employment laws just to start off with, just to have something rather than nothing, and unsurprisingly they turned to the UK. So in 2000 there's a piece of legislation in South Africa that models the UK legislation. It's very, very, very similar, with but uses different public agencies because of the different constitution. But one thing was missing. In the UK, the legislation gave rights to workers which were exercisable at industrial tribunals, which was the normal avenue for exercising employment rights. In South Africa, there were no industrial tribunals, so that the normal civil process had to be invoked. You had to go through the normal process of bringing a civil action. It was not accessible to people, it was expensive and time-consuming. So whereas in the UK, at that time, in 1998, it was relatively easy to go to a tribunal. There were no fees or anything like that. There was access to justice. As I suggested yesterday, with the introduction of fees, there's less access to justice for whistleblowers in the UK. But the problem for South Africa was that they hadn't quite figured out that the legislation depended on a particular form of access for whistleblowers. Again, Australia has led the field in federal and state legislation. The recent Commonwealth legislation, which is all-embracing, has some very important measures in it about access to the media, but what's been introduced there is access to the opportunity to use workplace forms of redress, which didn't previously exist. So Australia looked elsewhere, although they were leading in the field. They said, we can improve on this. So it seems to be only natural for any country to say, well, this is the kind of thing we need. How we're going to meet that need depends on what we can learn from best practice elsewhere. I gave the example yesterday, and I'll repeat it, Martin, of Ireland, where the Irish government said, you know, we're in a mess, legislation's all over the place, let's learn from our neighbour in the UK, and let's look at other common law jurisdictions and learn from their experience. I would say to the Czech Republic, look at your history, look at your neighbours, look at the Council of Europe principles, but don't just copy out what you think is a good model. That will make for bad law.
Can I just add something?
Yes,
we have a story in the United States, an analogous kind of cautionary tale of what I'll call maybe our cut and paste culture. So the danger of cutting and pasting from model laws or from other countries' laws. And it's, you know, I mentioned that we have a lot of different whistleblower laws that were developed in the 1970s and 80s, and one of them dealt with our worker safety and health. And the whistleblower retaliation claims were administered by the Occupational Safety and Health Administration. And those claims were investigated by people who were theoretically experts in worker safety and health. So what type of scaffolding was being used at a work site, whether people were wearing hard hats, all sorts of safety and health regulations, they would go in and investigate those. And then if there was a claim that a worker had made a complaint about something that wasn't safe, they would investigate those claims. And so for 20 or so years, they were the federal government retaliation experts in that small little area. Well, in the law that Tom mentioned, that was this huge expansion of whistleblower rights in the corporate sphere, Sarbanes-Oxley Act. The retaliation claim was for people who brought claims of accounting fraud and securities fraud and banking fraud, very complicated financial problems. So what did we do? Well, we said we have this group of experts on retaliation in the Occupational Safety and Health Administration, so we will have them be the people who investigate corporate securities fraud claims of retaliation, because this is just retaliation. So our corporate securities fraud whistleblowers have to go through a process where their claims of retaliation are investigated by the OSHA, the Occupational Safety and Health people, and they have no idea what accounting fraud looks like. Accounting fraud is incredibly complex. It takes a lot of training and education to find out whether these are even fraudulent activities. And so the initial stages, they're now getting better, they're now starting to incorporate other expertise, but the initial years of that act, whistleblowers were not being provided protection because they were being told by people who were kind of safety and health experts, well, you don't have a claim because you didn't really report accounting fraud. And my position is I don't think they really knew what accounting fraud was. They had just we had cut and pasted this procedure from some other law and put it in for this law, and it just didn't fit. So I wholeheartedly agree with David's point that when you create a law, you need to look at your own cultures and society and what works in those institutions while understanding the general precepts and ideas from other places.
Thank you. Tom, in fact, I have a slightly different question for you. Okay, you can comment.
I've put a lot of thought into that question, and I think the first principle is be very wary of laws that just look good on paper. That is only a start. In studying the different whistleblower laws in the world, the one that was the most impressive in challenging national security exceptions and complying with the Tshwane principles is Zambia's whistleblower law. And I don't think it would be realistic to have confidence in free speech rights for that country. So laws on paper are just a start. As far as evaluating laws on paper, however, I was a little surprised by Mark's attacks yesterday on the PETA Act in the United Kingdom, although a lot of the specific concerns there were well taken. I think the PETA model, however, as it's been refined in Jamaica and in Australia, is a solid model. There, my only real concern is that public freedom of expression is, while it's permissible, it's the exception rather than the rule. And you're never really sure if you've fallen within those exceptions until your case is over. So there's still sort of a structural chilling effect in the PETA model for public freedom of speech, in my opinion. The one that I've been most impressed with, that I think might be a good model for the Czech Republic to consider, is Serbia's new whistleblower law. It was outstanding in every respect except one. They don't have provision for administrative remedies, and that's important to have that informal, more expeditious way to enforce your rights. The U.S. corporate whistleblower laws are excellent, much stronger than our laws for the government workers, because they have the most advanced statement of fair burdens of proof, and because they allow the whistleblower to have the option of transcending politics, of having justice determined by a jury, of citizens who aren't connected with the power structure or any particular political party. But I realize that that's not always compatible with all legal systems. The model that I'd like to be a cheerleader for, and grateful for this question, is the one that behind the statistic that I said earlier, where we've increased our recoveries against fraud in government contracts by over 100 times. It's called the False Claims Act. And it was first passed by President Lincoln during the Civil War, very different personalities. And it was because so many Union soldiers were getting killed by their own weapons. The defense contractors were corrupt in the 1860s, just like they are currently. And we didn't have a big government agencies to inspect them all. So President Lincoln decided to deputize citizens to blow the whistle on fraud in government contracts. And it worked well during the Civil War, but it faded out over the years. It was revived in 1986. And this is a law which allows the whistleblower to go beyond dissent, to actually file a whistleblowing lawsuit to challenge the fraud. They don't just make noise. They go in and fight the battle to challenge the people who have abused their power financially. And it's America's most effective anti-corruption law. And I think that it has a lot of potential to challenge abuses of power in other sectors, not just fraud in government contracts, but fraud in serving the people of any nation.
Thank you. I'm afraid we only have time for one last question. So this one goes, I think it would be good to start with Tom again. Would you be able to mention concrete examples of protection offered by potential whistleblowers?
Concrete examples?
Yeah, what kind of protection can government or your non-profit organization offer to potential whistleblowers?
The role of NGOs. that NGOs that do their homework and work hard and are trustworthy are invaluable resource for whistleblowers. At a whistleblower NGO like the Government Accountability Project, we tutor people in their rights. We let them know when they have the law on their side and when they're completely on their own. We help them navigate the legal mazes that can be almost incomprehensible to somebody who hasn't had advanced training in those rights. So it's sort of the tutors and the navigators and the guides for whistleblowers. We also serve as their agents, as I said, being the matchmakers for the evidence and the information that they know about and which need to get out to all the people affected by it. So I think that whistleblower support NGOs are, particularly with new laws and new rights, indispensable to help guide people to take advantage of them and learn about them. But it's not just whistleblower NGOs who are important. It's the NGOs who have made lifetime commitments to the issues that the whistleblowers are raising. These are the people who have accumulated expertise and fully appreciate the significance of the whistleblower's evidence. And that's just very, very important. They also sort of know the political lay of the land. Who are the people who need to know that evidence within the power structure? What are the outlets where that evidence can make the most difference? A whistleblower is usually it's like trying to walk through a forest that you've never been through before. It's so easy to get lost. Well, those NGOs, they know that territory, and they can take the most advantage of it. Also, particularly until the Czech Republic passes its whistleblower law in countries that don't have one, NGOs can be the conduits for whistleblowers. When the legal rights are ineffective or they don't exist, we try to matchmake the whistleblowers with NGOs who are used to taking those risks and to be teaching them how to blow the whistle from their NGO perspective instead of from the isolated employee's perspective, because the NGO is familiar and comfortable and they take those sort of risks more regularly. I think that NGOs are just absolutely indispensable for whistleblowers to get away with committing the truth.
Thank you. I was just informed that we still have 20 more minutes. I'm sorry for the confusion. So the next question is to David. Are there any studies that show influence of the laws on whistleblowers' protection on revealing of corruption offense? Would you say that after the implementation of the laws, there has been a significant change of, let's say, like a number of cases which were solved, the corruption cases?
Well, we have the problem with association about with whistleblowing laws about how many, what comes forward, who has the responsibility for logging the concerns. I mean, we can't say we can't show any causal relationship with people reporting concerns in the legislation. I think there's anecdotal evidence that people may be more willing to come forward, but that's a rather indirect cultural effect there. I don't think there are in-depth studies, but the major problem that we have in the UK is that neither in the public sector or private sector is there a requirement to keep a record of who raises concerns, what the concern was about, how it was dealt with. There is a shift, a very recent shift, to impose an obligation on regulators, these are the external agencies, to keep records of the concerns that are raised with them, the number and type of them. But that's a formalistic move and is part of annual reporting. It is worth mentioning that the UK suffers from having one objective in its legislation. That is to protect people, and as Tom says, it tells you when you've been through the tribunals that what you did was protected. It gives you no guarantees in advance. The legislation in the UK is not geared to encouraging people to raise concerns. It doesn't directly put pressure on people to do anything about the concerns, to solve wrongdoing, or to keep records. And I think it's before we can do any research, we need obligations on employers, whether the public or private sector. We need obligations on employers to have procedures, to not monitor procedures, to keep records of the use of the procedures. So the UK is a very poor model in this respect, and it suffers. I think Tom again is a world expert on this. I think it's one of very few countries that has one objective, that is to protect whistleblowers, not to do anything about the messages that they are conveying.
Yes. Any other comments?
Yeah, we have a similar problem with statistics and studies. I think there's a lot of issues on trying to figure that out, but anecdotally, I talked yesterday about models of whistleblowing laws, and most of the ones that we were talking about are the anti-retaliation model, which, as David mentioned, deals with protecting after the fact, or compensating really a whistleblower who's been retaliated against. Our Sarbanes-Oxley law actually implemented what I've called the structural model, which we essentially required private companies to have disclosure channels that would allow a whistleblower to not have to report to a supervisor, but could report directly to the board of directors of a publicly traded company. And my great hope in 2005 was that those channels would help change the culture of companies. Much to my chagrin, I think what has really happened is that companies put in what we'll call window dressing disclosure channels. Turns out that surveys tell us that very few employees actually use those disclosure channels. Employees tend to report to their supervisors or to their supervisors, and very rarely go all the way around to the top of the company. And that can either be because that's just how employees report, or it can be that they didn't have much faith in those disclosure channels because they were just 800 toll-free numbers or anonymous hotlines, and they never got much satisfaction from it. Interestingly, in 2010, the United States passed what I'll call a bounty model on the corporate side. So Tom mentioned the False Claims Act on government fraud. In 2010, we passed the Dodd-Frank Act, which allowed whistleblowers to receive about a 30% reward for fines that were levied by the government against companies for committing corporate fraud if they provided the initial information. And the fear of that reward, anecdotally, has forced companies to bolster up those internal reporting mechanisms. And so what we're being told, and it's anecdotal, is that what used to be these window dressing models to, okay, the government's making us do this, we'll put in this disclosure channel. Now companies have a real incentive to encourage employees to report things internally and fix it, so that the employee doesn't go to the government to report that problem and try and get a reward. And so these incentives work in kind of odd ways, that by allowing employees to get that reward, all of a sudden corporations thought, oh wait, we really do want them to report internally. We might be able to fix this fraud and get it taken care of without having to deal with the government. And then so you can have these, I think laws do have this impact, but often in kind of ways you may not expect.
I couldn't overlook the irony that in a question about studies, we have, in my opinion, two of the three leading academic experts in the world on whistleblower laws here at this discussion. And Richard had to answer it with anecdotal evidence about the effectiveness of those laws. Because one of the big gaps in the process in most countries is keeping track of how these laws are working in practice. In the United States, there are no statistics How many times the whistleblowers win, how many times they lose, for what reasons. At GAP, I just look up every case and write them down and keep a chart and then do research on it. But it's not part of the structure. And that kind of feeds into, we don't just need studies, we need to have comprehensive transparency of how these laws are working, and then a structure for reviewing their effectiveness so that we can learn our lessons and stop repeating the mistakes that we make, which are inevitable during the early stages of these rights.
Then there is a question to all of you, and I would probably start with Mr. Michalek. Are financial awards a good tool for motivating whistleblowers?
V českém prostředí předpokládám, že pokud by taková motivace byla zavedena, tak by to mohlo zvýšit počet oznámení, nicméně mám za to, že celková osvěta by měla směřovat k tomu, aby ty primární motivy byly ochrana veřejného zájmu, ochrana právě nakládání s veřejnými prostředky a podobně. Je jasné, že pokud ta hlavní obava, která často brání oznamovatelům ty věci sdělit, je ztráta zaměstnání a z toho potom vyplývající nějaké finanční konsekvence, tak určitá míra jistoty, že ten člověk nebude po zbytek života prostě hledat aspoň nějaké podřadné zaměstnání, tak by pomoci mohla, ale osobně si nedovedu představit, že v českém prostředí by byla průchodná ta úroveň třeba 30%. My třeba na Státním fondu životního prostředí, když jsme vedli jednání se zaměstnavatelem z pozice odborové organizace, tak jsme právě chtěli, aby ty cílové odměny vázané na úspory podle paragrafu 134a zákoníku práce byly v relaci třeba 1–2% z té uspořené částky. Já vnímal jsem, že právě ten potenciál v úspoře ostatních provozních nákladů je až 50 miliard korun v České republice. A to se skutečně bavíme jenom o těch ostatních provozních nákladech v komparaci s tím, jak jsou vysoké v soukromých firmách. Nebavíme se o kapitálových výdajích a o investicích do nějakých infrastrukturních staveb. Takže pokud by prostě i 1% z takto uspořené částky mohlo jít osobám, které se budou podílet na těch úsporách, tak se domnívám, že by to mohlo být dostatečné.
David?
Yes, I have a strong view on this. I think I have to agree with Tom that in the US, financial incentives work. You may not like them, you may object to the morality of it, but the problem we have is the reward system works, but we've got to look at why it works in the US. You have to offer incentives for people to put their head above the parapet because these people are not going to work again. You report fraud in the public sector, defence, health or whatever, you're not going to work again. Other countries have different systems. For example, in the UK we have a system of employment protection laws. So that, and we have, I think, stronger trade unions as well, and we have a rather different attitude to rewards. Many people will be offended if you suggested to them that their reason for raising a concern was that they wanted money for it. They don't want to be heroes or traitors. They just want their concern to be dealt with. In terms of recent studies, I am in a position here to mention there is some research in the UK in 2014 in the National Health Service, which is the fourth largest employer in the world, As part of the independent inquiry into whistleblowing, a question was asked, what changes might encourage you to report concerns? What would make it more likely to report concerns in the future? And there were questions about anonymity, confidentiality, internal recipients. But the last question that was put was about financial incentives. And of the 5 measures offered, financial incentives was 20 to 25% below any of the others. And of course it has to be seen in that context. If you're talking about rewards and fraud and corruption, you can see how a percentage would work. But if you have comprehensive legislation that covers other type of wrongdoing, what kind of percentage can you offer to somebody that reports medical wrongdoing? You can't give them a percentage of anything. It's not appropriate to give them a reward in that way. So there is the question of the ethics. I can see if it works, go for it, but you can have a percentage of savings when you're talking about money. If you're talking about environmental damage, you're talking about medical negligence, it's not possible to work in that way. I think what is appropriate is for employers, perhaps in the public sector, to say, we will recognise what whistleblowers have done. We may make an ex gratia payment. The Inland Revenue Service, the tax authorities might say, well, you've alerted us to this, we will give you a present, if you like. Again, but people giving information to the police might get some ex gratia payment. I think it should be left at that level. I also take the view that if you want to alter the culture, you don't actually have to offer rewards. You can say to individuals at appraisal, you can say, are you willing to raise concerns? Have you raised concerns? You can promote people on the basis of their willingness to speak up. So there are many ways to encourage, to endorse whistleblowing, and I have to say that some people would object to the idea that money could be associated with what they, the activity that they engaged in. Sadly, in the States, one has to recognise that if you put your head above the parapet in the public sector about fraud, that's the end of your career. You have to be offered millions of dollars for that. But a more optimistic, maybe misguided optimism in the UK is that you will be vindicated and you will be not ruined in terms of your career. Again, it may be misguided, but it's a more optimistic approach.
What is your take, Tom, on the financial tools for the whistleblowers?
I think the first point to make about financial incentives is a reality check. Even with the most generous of these laws, it's much easier to win a small-town lottery than to get rich through blowing the whistle. I always warn people that, you know, if they lose in the lottery, they won't be ruined in their professional lives either, so they might want to think twice about that being their motivating factor. Another premise that needs to be clear is on financial incentives is there are 2 different models for financial incentives. There's the private attorney general model of the False Claims Act that I was discussing, and that came out of the Magna Carta, where people were suing on behalf of the king. And then there's the Dodd-Frank model, where you get a bounty for giving evidence to the government. And I consider that a little bit more like the Judas model of whistleblowing. And I agree that rationally it's justified because of the risks that people are taking. But I personally feel a little threatened by it because it undercuts our efforts to gain cultural acceptance for whistleblowers. So it's been a little bit of an obstacle in some respects. To directly answer the question, will this motivate more whistleblowers? Almost every study has shown that whistleblowers, even those using these laws, are not motivated by the desire to obtain profits. They're not motivated by the money. They're motivated by the fact that they can't accept some abuse of power, and they really need to challenge it to be able to live with themselves. And it happens to be a statute that provides money. It's been an extremely effective motivating factor for lawyers. The lawyers love the bounty statute, so all they have to do is package the evidence, and then they get a percentage of the percentage. And the Dodd-Frank whistleblower law firms in Washington, D.C. they're sprouting up like weeds in the springtime. There's so many of them. And in fact, I was talking to one at a conference recently, and he said, Jack, we've always been on the other side for years, and now you've joined my side, the whistleblower conflict. So what happened that you got religion? And he said, quoting from the line in The Godfather, he said, Tom, nothing personal, just business. And I think it's a valid point that there really shouldn't be a contradiction between doing well and doing good. In financial rewards, my preference is make the whistleblowers earn it to fight that battle.
Richard? Okay, then I will have one last question to all of you. If you could in one sentence advise someone or give an advice to someone who is considering blowing the whistle, what would that be? Maybe once again start with you, Mr. Michalek.
I really like what I've heard here. It is really valuable if you have a clear conscience and you can live with yourself. You can look at yourself in the mirror. You can look in the eyes of your children. So that really is a great value for you, and if you encounter a wrongdoing, you should really act in a way that you can then face yourself and your children and grandchildren.
Sorry, the one sentence, yes, I think it's the one sentence that's going to come after me, is that if you're contemplating blowing the whistle, you have to bear in mind that this is an act like no other act you've done before. This is not about a career decision. This is about your future. It's about your family, it's about your friends. So that's what I say to them. My advice is you don't blow the whistle until you have considered all of those things and consulted all of those people.
Thank you. Richard?
My one sentence of advice is get advice. You need to go to experts in this area and find the best advice possible and the best counsel and get help. It's very complicated. And it's potentially career dangerous, and you need to get help with it. Don't go it alone. That's more than one sentence, sorry.
It's all right.
I guess the way I'd sum it up is do your homework. This is a life's crossroads decision. It's as fundamental impact on your life as any other choice you'll ever make, probably. It requires a lot of advanced preparation and thought for whether to blow the whistle and how to blow the whistle. And hesitate to do it, but I guess I will. I'll be a little bit commercial. One course material for doing your homework is the book that I wrote about this called The Corporate Whistleblower's Survival Guide, a handbook for committing the truth. You can get it through Amazon, and it's 30 years of lessons learned. And one of the chapters goes into the survival tips. Share a couple of the top ones that I think are the most significant. The first is consult your family and all the other people who are going to be affected by this decision before you impose it on them. I've seen so many cases where a whistleblower, impulsively, heroically acted on his or her own without considering all the other people who depended on the whistleblower and found him or herself alone in the aftermath. Divorce is extremely common consequence of this decision. It's important to have a family solidarity. One, you'll see you probably may have seen the movie The Insider, Jeffrey Wigand, the tobacco whistleblower. He thought he was protecting his wife by keeping her ignorant. And it was a horrible shock. The family couldn't survive it when she realized what he had gotten into. Second is talk to your coworkers. Scout things out carefully. Don't give it away that you're considering blowing the whistle, but see how they feel about it. Maybe you're mistaken, and you need to know for quality control before you make a horrible mistake and accusation. And even if you're right, if everyone else there is so intimidated that you'll be all alone in challenging the abuse of power, that should severely affect, at a minimum, your tactics, if not your bottom line decision. A third thing that I always advise people is don't be too cynical. Give the system a chance without exposing yourself to unnecessary risk. That means offer the organization where you work the opportunity to do the right thing. Raise the issue in a supporting way. Not that, we're going to be crooks again, but, I'm concerned about liability. Is this going to backfire against us? What type of risk are we taking? Last night I sat next to the director of risk assessment at a major multinational corporation. And we were talking about whistleblowers reducing the risk to the company. Do it in a supportive manner, and then you can test the waters. Is this organization, is it just a mistake, or is it a conspiracy? And that'll be very important for figuring out your tactics. The fourth suggestion I think is very significant is secure your evidence before you're perceived as a threat to the organization. Once you are, the flow of information will be cut off to you. And you won't have the evidence you need to prove your case. So I advise people to stay anonymous as long as possible. And it's kind of like, the military tactic. Don't shoot till you see the whites of their eyes. Don't expose yourself as a threat until you have to. The next one is scout the NGOs to find out what type of support you're going to have in the community. Is solidarity going to be possible? And the last one is find a lawyer you can trust. This may be one of the most significant intimate partnerships of your life. It's not a romantic one, but it's a professionally intimate partnership. You have to be able to completely open up to that person, or for them to do an effective job. You have to know you can trust them. They don't have a conflict of interest, and that they know what they're doing. Those are kind of a half a dozen survival tips that I think can really make a difference as people make one of the most important decisions of their lives.
Gentlemen, it's been a pleasure. I thank you for all your contributions, and thank you all for your questions and your kind attention. Thank you and have a good day.